Your Lordship, the first issue, which is for consideration before this honourable bench, is whether the division bench of the High Court of Champaner was correct to dismiss Raja Retreat's claim for specific performance. The council will be dealing with this issue in a fourfold manner. Firstly, the council will be establishing how that the instant case does not satisfy the test of being a materially adverse effect in order for the respondents to claim termination of the contract. Secondly, the council will be establishing how this falls within the tenets of section 10 of the Specific Relief Act, which says that the contract is specifically enforceable, however subject to section 14 of the Specific Relief Act. The third fold of my submission will be that the conduct of the Summer Fest, known as Chaos in Champaner, while being a significant factor of our revenue stream, but was not the only revenue stream. And finally, the council will be contending that the petitioner has always acted in good faith and has also been ready and willing to perform the terms of the contract, especially because this is a suit for specific performance. Now, Your Lordship, if I may move with the first fold of my argument. I am obliged.
Which will be your first argument?
Lordship, my first argument is that the test of material adverse effect has not been satisfied or fulfilled in the instant case.
All right.
Yes, Lordship. If I may proceed.
Yes, yes.
Much obliged. Lordship, the attention of the bench is drawn to para 3 of the facts of the case, more specifically the definition clause, which basically defines what the material adverse effect is. It states that any event or circumstance which would reasonably be expected to materially and adversely impact the assets, liabilities, business operations, performance or prospects of Raja Retreats Limited as a result of changes to economic, political or market conditions, but not changes in laws, rules, regulations, orders or other governmental actions as applicable to Raja Limited or the industry. Now it is the humble submission of the council that in the instant case, COVID-19 as a pandemic and the subsequent lockdown which was imposed was clearly a governmental action and hence falls under the head clause 2, subclause 2, which is other governmental action. Now the council would go a step further to establish that there is a proviso to this clause, that provided that the changes, the very next page, Your Lordship, provided that the changes noted in the exclusion specified in para 2, subclause 2 above may be considered a material adverse effect to the extent that they have a disproportionate effect on Raja Retreats Limited in comparison to other companies in the very same industry. Now, it is the humble submission of the council that COVID-19 as a pandemic, which was unforeseen and unprecedented, had an impact and ramification on the entire industry as a whole. Therefore, there does not arise a circumstance where Raja Retreats Limited has been disproportionately affected when compared to other concerns in the very same industry.
But you are the plaintiff, right? You are Raja Reddy.
Indeed, indeed.
You are representing Raja Reddy.
Indeed.
So just tell us how the material adverse effect will have a bearing on your suit for specific performance, because it's not affected you.
Indeed, Lordship.
Material adverse effect is only on
an argument.
Indeed. However, the reason why the council is defending that it does not fall within the parameters of material adverse effect is because that was invoked by the respondents to basically terminate the contract. Therefore, I must establish and prove before this bench that it did not constitute a material adverse effect for the respondents to even terminate the contract in the very first place. Much obliged. And I am thankful for that question, Your Lordship. Now, Your Lordship, as I have already established that the material adverse effect clause has not been satisfied, therefore, there arises no ground for termination. And Your Lordship, as already reiterated before, that the lockdown imposed and COVID-19 was something unforeseen and unprecedented, which was not within the control of the petitioners. Now I'll be moving to the next fold of my argument, which is to state that section 10 of the Specific Relief Act is satisfied in the instant case, and I would like the attention of the bench, if they may, to section 10 of the Specific Relief Act. Lordship?
Yes.
Section 10, if I may read. Specific performance in respect of contracts. The specific performance of a contract shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, section 14 and section 16. Therefore, this needs to be read along with section 14, Your Lordship, which brings me to section 14. Contracts not specifically enforceable. Contracts not specifically enforceable. The following contracts cannot be specifically enforced, namely, subclause A, where a party to the contract has obtained substituted performance of contract in accordance with the provisions of section 20. So, Your Lordship, the corollary to this is, if the party to the contract has not obtained the substituted performance of the contract, then it means that the specific performance can be enforced. In this instant case, it is the humble submission of the council that the substitute that the council is referring to is the very fest, that is the Chaos in Champaner Fest, which is usually hosted in summer. But there were potential talks for a winter edition of the fest. Therefore, that even if the councils for the respondents contend that the fest itself and the cancellation of it is a materially adverse effect, we were making everything which was within our frame to to provide for an alternative arrangement. Now, but I will be focusing more on.
What is the substantial question of law you are arguing?
Lordship, the substantial question of law that I am arguing is I am challenging the division bench court which basically set aside the decree which was in my favor.
That's not a substantial question of law.
Lordship, however, in the instant case, the substantial question of law being that it is against the principles of contractual law, more specifically when the party to a contract can invoke unilateral termination of the contract. In my humble opinion, that is a substantial question of law.
We are examining this under what jurisdiction?
Under Article 136, Your Lordship.
So then how are we supposed to look at it?
Your Lordship, if I may state, the court is required to examine if the division bench's reasoning of setting aside the decree is right or not, Your Lordship.
Is that enough?
Your Lordship, and also to...
Under 136, you will have to convince us that there is a substantial question of law of public importance.
Indeed, Your Lordship.
The court might have committed an error, but still, why should we interfere?
I acknowledge, Lordship. However, in the instant case, since we are an aggrieved party and the deal was worth 1,200 crores and it was a share purchase agreement to acquire my company, therefore, I feel that it has a substantial effect on the industry, the hospitality industry in general, which warrants the interference of this court, Your Lordship.
Will that qualify as a question of law?
Lordship, this is the submission that the council has to make. Ultimately, it is for your Lordships to decide it.
Go ahead.
Lordship, moving on to the next fold of my argument, Your Lordship, which is to state that in the instant case, section 14, more specifically clause D, Lordship,
yes,
if you may have it.
Clause D,
It states that a contract which in its nature is determinable. Basically, this clause confers the power to the respondents to unilaterally terminate the contract. The council completely acknowledges that. However, as already established through my previous limb of the argument, that the conditions to invoke unilateral termination, more specifically, the material adverse impact has not been satisfied, because of which the respondents cannot claim unilateral termination of the contract. Therefore, this does not fall within the facets of 14D, and therefore it falls within the facet of section 10, wherein the specific relief must be ordered for and enforced.
On what basis are you saying it's determinable, not determinable?
Your Lordship, I am not saying it's not determinable. I am saying that they do have a unilateral right to terminate the contract within the clause of the contract itself. However, what I am trying to state is...
Can you tell us on the basis of the termination clause?
Indeed, Your Lordship.
Interpret on termination.
Indeed, Your Lordship.
18, no?
Yes, Your Lordship. Clause 18. Either party may terminate this agreement for a breach by the other party of the conditions set out herein with 7 days notice. Further, captains in limited shall have a right to immediately terminate this agreement if, on the closing date, any of the conditions precedent to closing, that is in clause 7, remain unsatisfied and have not been waived in writing by captains in. Now, Your Lordship, if you look at the clause 7, which is the conditions precedent to closing, it clearly mentions that there must be no material adverse effect. Meaning, if they can establish and prove that there was a material adverse effect, then they can claim unilateral termination. But I have already proved to the best ability that there was no material adverse effect in order for them to claim the relief of unilateral termination, which is why it's my humble submission that it does not fall within the facet of 14 subclause D, and it should be enforced under the facet of section 10. If I may proceed with my further arguments. Much obliged, Lordship. Lordship, as I have already stated before, and I would like to reiterate, that in the instant case, the Summerfest, while a significant factor, was just one revenue stream and the business has other income sources. This is because, Your Lordship, the respondent councils will rely on the fact...
Which point are you arguing now? Which point have you taken up?
The third fold of my argument, to say that even if they consider that the Chaos in Champaner Fest, which was a summer edition of the fest, was a significant revenue stream for me, but that was only one revenue stream and I had multiple revenue streams. So that itself will not amount, or rather constitute a material adverse effect. So, Your Lordship, may I submit? Much obliged. Your Lordship, the council would... Yes. The council would like to submit that in the instant case, though COVID-19 was a major pandemic, but it was only a temporary setback. It was not a permanent one. Therefore, that itself did not limp or paralyze me of my ability to conduct future editions of the fest, or also to conduct a substituted edition of the fest, which is to say, instead of the summer edition, a winter edition of the fest. So that is my point number 1. Point number 2, Your Lordship, which is very important, the facts of the case. More specifically, if I may draw Your Lordship's attention to para 6 of the facts of the case, which clearly states that the 2 resorts owned by the petitioner in Champaner began receiving regular bookings, and the occupancy rate for the 2 properties as of June 2020 was only 14% lower compared to the 2019 figures. So this itself shows that despite the pandemic, my industry is reviving, and also it's a revival which is at a very substantial rate, because despite COVID, my bookings have only reduced by 14%. Therefore, it shows that the trajectory is towards an upward pattern and not towards a downward pattern. Therefore, it's my humble submission that we had multiple income sources, and even if they were here to contend that the fest was a significant part, but that itself does not constitute a material adverse effect.
But
And
is it, we can exercise the option of asking them to pay you some damages.
indeed, Your Lordship. However, in the instant case, it's my humble submission that a compensation per se is not an adequate relief. Simply because, Your Lordship, if the share purchase agreement as it stands so is not enforced, it's the humble submission of the petitioner that would lead to an irreparable loss.
How?
Because, Your Lordship,
It's only a money matter.
indeed, Your Lordship, but
You will get some kind of an interest for your
Indeed.
investment.
indeed, Lordship, the reason why the petitioner submits so is because from the facts of the case, it's revealed that after protracted negotiations for 7
of specific performance?
Your Lordship, that is a very valid question. However, in the instant case, since the very contract also is covered within the facets of contractual law as well as the specific relief act, which is why we felt it would be an appropriate remedy if we pursued for specific performance over a wrongful termination.
That's why His Lordship is saying that you can be compensated for your loss.
Indeed, Your Lordship. However, we feel that justice would be done for both the parties if this very share purchase agreement as it stands so is enforced, Your Lordship. Indeed. Lordship, if I may proceed further, that this is my final submission as well, that the petitioner has always acted in good faith and has also been ready and willing at all times to perform the terms of the contract, especially the essential terms of the contract. This is because, Your Lordship, even from the very facts of the case, it can be seen that even till March, before the lockdown was imposed, we were in continuous negotiations with the government to ensure that the fest is conducted. However, something as unforeseen and unprecedented as COVID happened, because of which a subsequent lockdown was imposed. Therefore, that itself is not within the realm of our control. Whatever was within the realm of our control was performed, and we were ready and willing to also perform the same. Therefore, the council would like to rely on the principle of he who seeks equity must do equity, and therefore, when the plaintiff in the instant case has been able to showcase that he has been ready and willing to perform his terms of the contract, then I humbly oblige that this court upholds the decision of the single judge and enforces a decree for specific performance. It was an honor arguing before this bench, and if the bench doesn't have any other questions, the council would like to conclude his arguments.
Yeah, that's
It was an absolute honor, Lordship. I am much obliged.
Thank you very much.